a special resolution passed at a general meeting shall be necessary. So once this resolution is there, then it is doable. The company shall disclose to the member in the financial statements the full particulars of loan given, investments made, or guarantee given or security provided, and the purpose for which loan or guarantee or security is proposed to be utilized by the recipient of loan or guarantee or security. No investment shall be made or loan or guarantee or security be given by the company unless resolution sanctioning it is passed at a meeting or board with the consent of all directors present at the meeting and the prior approval of public financial institution concerned where any term loan is subsisting or is obtained.
Yeah.
Provided, well, this is another proviso, but I am covered by this. My lord, may kindly see 7. No loan shall be given under this section at a rate of interest lower than the prevailing yield of 1 year, 3 year, 5 year, or 10 years government security closest to the tenor of the term of loan. No company which is in default of, this does not apply. Now, my lord, what is the punishment provided? 13, subsection 13, my lord.
Yes.
Subsection 30 says, if a company contravenes the provision of this section, the company shall be punishable with fine which shall not be less than 25,000 rupees but may extend to 5 lakh rupees, and every officer of the company who is in default shall be punishable with imprisonment for a term which may extend to 2 years, and fine which shall not be less than 25,000 rupees but which may also extend to 1 lakh rupees. So, my lord, my case entirely is based on this submission that if the company where I happen to be an employee has given a loan lesser than market rate of interest or government rate of security, my lord, then this is covered by section 186, not 447. Because for 447, basic ingredients of connivance should have been present. Oh, my lord, once resolution is passed, I am covered by this. 186 is a complete code in itself. Had it been a provision where no punishment was provided, then in that scenario, it would have been stretchable to 447. But for 447, once it's brought on record that there are resolutions, there are authorizations on record, then it is covered under 186. So, my lord, that is the basis, the premises of my argument, that if the predicate offense squarely falls in some other section, not the predicate offense, then I should not be allowed to face trial. In this matter, my lord, what happens that I am not running away from justice. I have not been arrested. And now, my lord, most importantly, not even a single proceed of crime has traveled to me or I have consumed. There is not even a single benefit which this company has given to me apart from this paltry salary, my lord. 85 years of age, my lord, retired in 1999, my lord. He's working with the company and he's keeping himself busy. My lord, on the personal side, these are the 2 additional facts which I have pleaded in this my rejoinder, supported by medical document, my lord, that he does, this petitioner does not have any son. He has 3 daughters. All 3 of them are married. 2 are abroad, my lord. One is in India and she's settled with her family. And his wife is also very sick, my lord. That certificate is also on record. That wife also requires nursing, my lord. He himself has been operated upon his right knee, my lord, and left knee is now proposed. Prostate operation is also due. He has some skin disease also for which continuous medication is going on. This is all in this background that I have not been arrested by predicate agency. Now, my lord, this is a proceeding where should I be arrested at the instance of court? Prosecution agency does not want my custody, my lord. They do not want to investigate me. There is nothing against me. To me, 4 summons were sent, my lord. First 3 summons, I responded to it that I am not well. I'll come some other day. 4th summon, I appeared. My statement is recorded.
Where is that chart in the complaint? Which
of
the date on which you appeared before the investigating?
My lord.
Agency? There is a chart in
Yes,
complaint
that
somewhere.
chart is there, my lord Bhaskar. It's
But
just
this is
before.
page number 102. Come to page number 102.
My lord. I'm obliged.
There's a table number 23 at the bottom.
My lord.
Your name is?
is at serial number
You are IH
2.
Siddiqui.
Yes, I.S. Siddiqui, my lord.
So you did not appear on
3 occasions.
3 occasions. You did not appear. You
Well,
He
appeared on
appeared in
9
only one occasion.
And all these 3 summons were responded because of bad health. They did not go unattended. My lord, this is a matter being prosecuted by an agency which is not only trigger happy, my lord, they arrest even before hat is dropped, my lord. Had there been any proceed of crime with me or any further investigation required with me, I would have been with them in their care, my lord. I don't know, my lord. This is not a case where with click of mouse, as Vijay Madallal Chaudhary notes, with click of mouse, millions can be transferred in a second. Nothing is with me, my lord. Even there is a civil proceeding, my lord, which is also part of PMLA, where attachments are done, my lord.
So any property of this applicant has also been attached.
No, my lord. He is not party to any provisional attachment order, my lord, because he was thoroughly investigated.
Yes.
And nothing has traveled against him. So, my lord, now, if my lord would recollect, the other day, my lord had heard that Paras Bansal, my lord, Paras Bansal's citation, which was brought to court's notice.
Yes.
My lord, I had the opportunity to assess your lordships before Supreme Court, my lord, in that matter. Court was also of the opinion, my lord. Similarly, in Sanjay Raghunath Agarwal, that is also, as I have seen that it is pleaded in the pleadings, my lord. That also I had opportunity to assess, my lord. What is the requirement to be inside custody?
Yes.
Had there been any documents which are in my personal possession, any property which I am hiding, any proceeds which I should be deprived of the benefit, and they are proceeds of crime. Well, Lord, one more very important aspect of this matter is the entire proceeding under PMLA is for confiscation of proceeds of crime to the central government. Well, Lord, this complainant, Mr. Khosla, who has lodged complaint, he is not going to get this. They want to take, and where it has been used. It has been used for hospitals, my lord. It has been used for medical colleges, my lord, and other public places, my lord. Now, how it is done? This is also not allegation that monies which have traveled to this petitioner or the company has evaporated, has vanished. My lord, all whatever was whatever is there, it's already, everything is reflected in the balance sheet. It has been referred to. It has not been said. The only allegation emanates from that interest was lower than the government security yield. This is the primary genesis of this, my lord. So my humble submission is this: considering the old age, family condition, and minimal role of this applicant, my lord, I deserve to be enlarged on the bail, my lord. I need not be arrested. I will participate in trial, my lord. I am not running away. Had it been a case, my lord, I could have been a best at a witness, not as accused. This is my humble submission, my lord.
Yes. बताइए.
Also, my friend has argued in relation to the offense of schedule has not been made out against him. The also may kindly come to page 772.
7
772, Lords.
of your reply.
Yes, Lords.
My copy is not numbered, sorry.
Oh.
I'll just check it. 7 of 130.
772.
772, Lords. Paragraph 6.3.
Yes.
Also, there were 3 complaints before the ROC under the provision of section 447. It is the complaint wherein the present applicant has been named also. As per complaint number 12/2021, dated 30/12/2020, following 4 individuals have been made an accused. First is the Public General Hospital Private Limited.
People General Hospital.
People, yes.
Yeah, People General Hospital Private Limited, for which the present applicant has been the director also. And the third name is Istiaq Hussain Siddiqui. It is his own name also. So he has been made an accused in this particular complaint, which was filed in relation to the schedule offense before the ROC, Lordship. Now, Lordship, why I am referring to this particular complaint, Lordship? Because this complaint has been sought to be quashed before this Honorable Court itself, Lordship. Lordship, may kindly come to page 880.
Gwalior bench order.
Yes, Lordship. This is the same complaint. Page 881 onwards, Lordship. The first paragraph itself is also which reveals that it is in relation to the complaint number SC/12/2021. In the light of the facts severed in the grounds urged in the instant application, this Honorable Court may kindly be pleased to allow the instant application, thereby quashing the proceedings bearing the complaint number so and so. This is the same complaint wherein the present applicant as well as the company for which he has been the director has been made an accused.
That is the complaint under section 447.
Yes.
Complaint.
Since he has been referring that the schedule offense has not been made out. So I am coming to the point by referring to this order laws.
Yes.
A special judge, Gwalior under section 482 of the Code of the Criminal Procedure so and so, an order dated taking cognizance and issuing process, and be further pleased to quash all other proceedings thereto in the interest of justice and to pass an order that this Honorable Court deems fit and proper in the interest of justice. And then paragraph 3rd onwards, Your Lordship, the entire facts has been elaborated in respect of the role of the present applicant as well as in the capacity of the director of the company,
Yes.
People's General Hospitals, Lordship. If Lordship permit me, then I'd like to read the paragraph 3 on it.
You all,
Otherwise, though I've already read in the last date of hearing also, I refer to it, Lordship.
you can skip this.
Yes, Lordship. So now, Your Lordship, may kindly come to just concluding paragraph. Paragraph, Your Lordship, 24 onwards.
Yes, fully.
Page, internal page 10 and the 889 of the PCA. On merits, allegation are such which requires trial to reach to the truth.
Yes.
This court does not venture into the factual details on the merits of the case in the specific terms, lest affect the trial, but certainly constrains to discuss that the allegations are such which attract trapping of the section 447 of the Act of 2013. For trial prime facie,
No.
transactions were spread out in the years together, and the funds of the company were allegedly siphoned off to a different entity. Therefore, only the trial would unfold the truth. In the considered opinion of this court, the petition preferred by the petitioner fails and has no merits to entertain under section 482 of the CRPC, the scope of which constricts one's parameter as mandated by the apex court. In the case of state of Haryana and others versus Bhajanlal, AIR so and so, and the subsequent judgments are not satisfied, section 482 of CRPC cannot be invoked in the exceptional cases on the basis of the ground as delineated by the apex court time and again. Here, this court desists to invoke the such jurisdiction in the given facts and circumstances of the case laws.
Yes.
So that petition has been dismissed, and subsequently the matter went to the Honorable Supreme Court as well.
Yes.
From there also that petition, especially petition as preferred a lordship, that has been dismissed. Meaning thereby, lordship, that the schedule offense still has been in existence. My friend has argued, referring to some provisions of the Company Act, which is not at all applicable at this stage. It cannot be reopened again when already the finding has been recorded in the judicial side by the Honorable Court. And the matter has already been affirmed by the
According
Supreme
to
Court.
his contention, this offense ought to have been registered under section 186 instead of
That's-
447. That is what his argument is.
But again, that issue, also 447, already he preferred the petition and invoking the provision of section 482
Yes.
because the complaint was registered under the provision of section 447. Whether at this stage can he go back and refer to some other provision that no, that offense should not have been made out under that provision, but it should be made under these provisions.
Yes.
The second submission is that also that this petition even is not maintainable. As to why?
So far as this applicant is concerned, he is connected with how many companies and which companies?
You'll also may kindly come to page.
You come to that paragraph.
Yes,
Here
yes,
is the
Lord.
paragraph of complaint.
You'll also may kindly come to page 855.
855.
Yes. And before that, also I will refer to page 850.
850. 850.
850. Here I am referring to the statement which has been recorded under section 50 of the Penal Act 2002 Lordship, of the present applicant. What he says,
From 20, you can read.
20.2 Lordship.
0.2.2.
Yes, yes, Lordship.
Padhiye.
He-
20.2.2.
20.2.1 itself also is required because इसमें सर इनका status आया है कि as to what status he was working in that company. 20.2.1.
Yes.
He stated his job in 1939 and so, BHEL Bhopal, and retired from the post of additional general manager so and so. In 1997, after retirement, now it is very relevant also, he joined People General Hospital Bhopal as director
Yes.
in 1999 and is still working in the PGH International Private Limited as a director. He is the director in Messrs. People General Hospital Private Limited since 26/5/2019 till date. Apart from that, he is also the director of PGHS International Private Limited and Messrs. People's International Service Private Limited since 6/8/2015 to till date. He was responsible for all the operational aspects of the PGHSPL with a view to generate adequate income for the hospital run by PGHSPL and also looking after operational parts such as survey, constructions, maintenance services, and so and so. Further, he provided a written submission wherein he mentioned that he has signed the joint venture agreement dated so and so, executed between the People's International and Services Private Limited and Sri Suresh Narayan Vijay Bargi for launching of certain joint venture projects. And for the same, he was authorized by a resolution dated so and so in the board meeting of so and so of Mrs. People International and Services Private Limited. Further, he has also signed the agreement 17/1/2011 as authorized signatory of the Messrs. People's International and Services Private Limited. During the statement of Sri S.N. Vijayvargi, he stated that the role of Istiaq Hussain Siddiqui, wherein he categorically stated that he was looking after the construction work of the People's Group and also looking the day-to-day functioning of the Messrs. People's General Hospital. He had no role in taking decision in respect of the lawsuit. May kindly come to the role of this company. It is at page 855, for which he was the director.
Yes. Paragraph.
Paragraph 24.1. Role of the Messrs. People's General Hospitals Private Limited.
Yes.
Messrs. People's General Hospital Private Limited is a company established in 1991 under the Companies Act so and so. Sri S.N. Vijayvargi claims to have invested rupees so and so in PGHPL. Further, the foreign investor Alliance Industry Limited invested rupees 144 crore 18 lakhs 37 so and so. 98% of the investment. However, Sri S.N. Vijayvargi and family hold 53.48% of the share in PGHPL, while the foreign investors hold only 47.52% shares in the company. PGHPL was the first entity to start receiving FDI from abroad during 2000 to 2006. Sri S.N. Vijayvargi, Sri Istiaq Hussain, who is the present applicant here, Sri Ramvilas Vijayvargi, Smith Urmila Vijayvargi, Savitri Devi, Smith Neha Vijayvargi were the directors in the company. People's General Hospital Private Limited, through its then director, Sri S.N. Vijayvargi, Ramvilas Vijayvargi, appears to have committed the offence of the fraud under section 447 of the Companies Act so and so, has adopted devious means and the methods while allocating shares, bonus shares and buyback shares as detailed in paragraph 8, though its directors has siphoned of the money received as FDI by giving away the money in the form of the loan, advance, buyback of the shares, etc. to S.N. Vijayvargi and other entities under S.N. Vijayvargi control, and by doing so has denied itself the opportunity to pursue its business as per its objects and create assets of their own, resulting in depletion of its resources over the period of more than 20 years, which has been utilized to enrich S.N. Vijayvargi and the entities under his control. has distanced the foreign investors from the investment they made in the PGHPL by moving the money away from PGHPL to SN Vijayvargi and the entities on which the foreign investors did not execute any direct control, and by doing so has injured the interest of its shareholders, foreign investors who invested more than 90% capital in PGHPL. People's General Hospital Private Limited, through its the director CSN Vijayvargi, Ramvilas Vijayvargi, directly attempted to indulge the offense of money laundering and actually involved in the process or activity connected with the POC by siphoning of the money received in FDI as PGHPL through fraudulent and dubious methods and the means while allocating the shares and the loan shares, while buying back of the shares by the transferring of the money received as SBIB to Sri SN Vijayvargi, SGPN and other related entities as loan with zero or very low interest rates in the form of security deposit, advance rent and other such terms used in the different instances in the books and the agreement.